We lost files, we lost most of our equipment because the river came in, the sea came in, and then the roof of the building, also that was lost.
So the court in itself, to be independent, must have a system that is robust enough to withstand any disaster.
We're moving towards a paperless judiciary.
A judge can walk with his tablet, access the portal, all the documents filed by the lawyers right there.
This change is good because the change is not motivated by one individual. It's motivated based on justice.
And so here is the official click.
The Eastern Caribbean Supreme Court is a regional court. The court is not a court in a single island. It is a court comprising 9 member states and territories. It's separated by water.
We also have different legal profiles of what we're really concerned with in each of these states.
You would have your magistrates court level, your high court level, your court of appeal level, with 9 registries and court staff ranging from 50 to 30 persons, each person with a specific task.
In each state, you have high courts that are operating, but those courts all come up to the next level, which is the Court of Appeal. And the Court of Appeal is basically centered physically at the court's headquarters here in St. Lucia.
The court is set up to ensure that every person has a place, a foundation to be heard, should they have concerns that need to be addressed.
Access to justice, what this is all about. It's not just the case of bringing a litigant to the courthouse to get his or her case heard. That's part of it, of course. And we have to keep the doors to our courts open and make them even more open.
And of course, ensure that it's done in a very fair, consistent manner to where their rights and their ability to be heard in a formal setting takes place.
What better way to connect all of the courts, the court offices across those 9 island states by way of a digital mechanism through the internet?
When one considers the role of the legal system in any society, it's critically important that the legal system and the institutions that comprise that system also make the shift and adapt. The ability to incorporate technology and make the court work more efficiently is fundamental to that.
But we're in the day and age of being digital, and the courts must adjust to that.
I think if we have a fully electronic integrated system, it will help us better to manage our filing system. And that will lend itself to better access to justice in itself. And to me, one cannot speak about the administration of justice if the ordinary man doesn't have access to the system.
It is critical. It is integral, because unless the public has confidence in the judiciary, in its fairness and in its integrity, that is really what gives it its not only its purpose, it is what gives it its authority. Authority of the courts must come from the people.
We are trying to be customer service oriented. We are trying to be as efficient as we possibly can. We are trying to change perspectives of how the court has been viewed for the last 50, 60 years, whether it's in our region or in the world.
And this speaks volumes, because we are seeing where technology has now become an integral part of how we communicate on an everyday basis.
We have gone from simply paper filings to electronic filings, and we've done that for a long time without really appreciating, I think, from the time everyone became comfortable with emails. The court gets emails, email filings every day.
These filings were then pulled into GEMS in the sense that they were either attached, if they were documents, and entries made into GEMS subsequently. So these two systems were not integrated.
The courts had taken the initiative to leverage what we would call open source technology or free technology, which was simply Google Docs. So that in itself gave us the comfort that culturally they are ready to move to the next step, where they would be wanting a more end-to-end seamless type of platform.
We thought that we should have an integrated system. So we looked around, we developed what we call our requirement specification documents.
What the court has been seeking to do is to look at methodologies by digitization of its processes. What that does is it allows for quicker research, it allows for quicker retrieval, and electronic filing and electronic case processing.
I believe it was March of 2016, we proposed to the ECSC a diagnostic study which would allow Crimson Logic to understand what is the current climate for the judiciary and their jurisdictions.
We had a number of demonstrations. They were listening to what we wanted in terms of the needs of our court and also what they had developed to date.
So what differentiates Crimson Logic's Judicial Accelerator? What it does allow is for agility. As they grow, because they're a young jurisdiction, the platform will be able to grow organically with them.
So we've had to create a tailor-made package which can work for all of our territories and states. That means that it's going to take some time before we iron out all the wrinkles.
I think there have been challenges that the Eastern Caribbean Court has faced that has created delays.
There is an irreducible minimum of procedures that you can get rid of because of the need to give people a fair hearing. But if you can save time in that process, then you can avoid that horrible truism that justice delayed is justice denied.
There is a wide range of cases that do not require full-blown hearings in courts and so on and so forth, and that would massively benefit from a more fluid online process. And I'm not implying that the current judiciary is not, or the Eastern Caribbean Court is not efficient for the time being. It's just going to build on that.
And that's where the E-Litigation Portal comes in. It speeds up that which has been slow in our system to date. And if you can speed up the administrative side of justice, you're going to be doing everybody a favor.
What the E-Litigation Portal is doing is gradually taking us towards this paperless way of doing things, or how we'd like to refer to it as an e-judiciary.
So you'd have the litigants, you would have the lawyers, you'd have the case managers, you'd have the judges. With e-litigation, everyone actually comes on board.
It's a scheduling system. It's a filing system, which GEMS clearly isn't. So you have GEMS packed into this portal with so much more.
It is the entire gamut of the judicial ecosystem, from the time a lawyer or a natural person files a document to the time a judge concludes the case.
The e-litigation portal is a web-based solution that allows different parties, even the litigants, who can log on to a public inquiry search system and see when is the next court date. Simple as this.
And so here is the official click. Yes. There we are.
It's finally here. The ECSC E-Litigation Portal is now live for the Commercial Court and the Court of Appeal.
We have seen them take ownership of it. And the training sessions have been led by the ECSC IT team.
And it provides what we hope to be a safe portal where persons can file, pay fees, and manage their cases.
That in and of itself is a great achievement, because do you have to attend physically? at a court office to do that? No.
It means in the long run that justice will be accelerated, that people will have an end to their matters quicker.
What many people don't realize is that with a very straightforward standard application to the court, there are about 40 different administrative steps that need to be taken.
Every single filing that you take in, it must be recorded in a register with times, filing stamps, date stamps. You must deliver those copies again. Then you must take those, you must bundle them. They must be in a certain order. They must be in a certain folder. They must be filed in a certain order. So all of these things. So the staff, now you're going to be doing those things, but you are doing those things through the use of your computer. Importantly, not losing a document.
It removes the paper shuffling in a major way. That's why I started by saying we're moving towards a paperless judiciary.
You will spend less time looking for a filing cabinet in the judge's chambers or even in the registrar's office.
This system is now hosted on the Amazon Web Services on the cloud, which means it is open 24/7, anytime, any place, any device.
A mobile phone, a tablet, laptop, and so forth. So you want to find information on your case. You may not have internet generally home, but you have data on your phone or your mobile device. You can access that data.
What you have in this system, I think, is a good way for all our stakeholders to really be satisfied with a product that is just superb in its nature.
This stage that we are about to enter takes us to the next level in using e-technology. It is where we have to go. It is where we must go if we are going to remain ready for doing business, if we are going to remain responsive to the needs of the people that we serve.
Our courtrooms aren't getting any bigger and the volume of work is increasing.
A lot of work is done behind the scenes, not in the public side, in terms of preparation, hearings, reflections and writings thereafter to deliver a decision, sometimes overnight.
Our judges are hardworking, but they are limited in number. And if you look at the statistics and the number of matters that are heard and the number of matters that come before the court, and you stop to think, how could 3 judges hear all of these matters?
2017, let us just state that here, that would have been basically during the hurricane seasons, and we had court closures, but we yet had, for example, in the Court of Appeal, there was a total of over 800 matters filed. The court heard over 1,300 appeals, applications, chamber matters, and delivered over 800 decisions. In the High Court, we had over 7,000 cases filed in the High Court. So the volume of matters in the Court of Appeal reflects in every respect the volume of matters in the High Court that makes its way up to the Court of Appeal.
And when you have all of this action, you have all of these cases being filed, you have to have persons who take care of each case, whether it's a magistrate's court, a high court, whether it's criminal, civil, family, commercial, or it's a matter in the appellate court.
We do this, it's about 30 judicial officers across the 9 member states. In terms of the Court of Appeal, we have 6 members on the Court of Appeal, and that includes me as Chief Justice, as President of the Court of Appeal. It's a load that is higher, I think, than any other court in the region.
I think that we are absolutely doing the best that we can, but we're trying We're trying to strive for better, as everyone else does.
This is one of the reasons why we have to go to this method of electronic filings and also processing of your cases, because the volume, the time that it takes is tremendous.
The Eastern Caribbean Supreme Court's E-Litigation Portal offers a comprehensive suite of true end-to-end court technology with features that will have a transformative effect on the legal landscape in the OECS. Court proceedings in the jurisdiction will transition from an archaic filing system to a more efficient, streamlined electronic process.
This is our vault area, where we store not only court files, but all the files at the registry departments.
Recently, in one of the registries, not here, a piece of global litigation was started. And the claimant's legal team spent a whole week in the registry filing about 250 claim forms. With the e-litigation portal, all that could have been done in a couple of hours.
Let's say you have a 4-week trial. As part of preparation for that trial, you have a disclosure process. And in big trials, that disclosure results in a huge amount of documents having to be printed and bundled and put before the court and being available during trial for the court to use.
And I remember we did a case a few years ago where we had to, the parties, we had to take bookshelves into court because there was just not enough space for all the material.
We have files in the registrar office, deputy registrar, court administrator, both criminal and civil courtrooms, in the vault where we store some in archives. So sometimes it's difficult to access files when you need it urgently, with so much paper.
So in terms of having ready access to files, this would be the better option, to have it in the cloud where you could have easy access to it as opposed to having more storage space to store the files.
The portal is designed using what we call a real intuitive graphic user interface, in the sense that with case creation and other processes, there are various steps that the system indication can show that where things are at in the process.
Every step of the way, everything is logged. Every process is going to be followed. It has to be followed because you can't miss a step. The system will not allow you to miss a step.
I must say that as I went through the training, I was totally blown away by the system, especially by its simplicity and its ease of use. It's a very practical, hands-on, easy to use and easy to understand system.
We have different levels of user groups and different access rights associated with those users. So we have judges with different access rights, case managers, registrars with different access rights. With the law firm, we have the administrators, along with normal legal practitioners and legal secretaries, all with different access rights.
For the registrars, our signatures, everything can be done electronically. We can see what goes on in a matter, see where we need to come in.
It helps my job as a judge because at the start of a matter, a judge is assigned electronically by the e-litigation portal. And that gives the judge a supervisory function, as it were, over the case from day one.
Sometimes we've had cases where documents may have been filed and they simply have not reached on the court's docket. So one wants to avoid as far as possible those types of scenarios where you'll then later learn a decision may have been taken, but not with the benefit of documents which may have been filed at some point, at some later point.
The judge will have all of the papers in their case, and I think that that's very, very important because so often matters cannot progress because the judge hasn't received the papers or the papers haven't been put on the file as yet.
So even though the timelines still apply because it's governed by the rules of court, the fact is you can do your filings at any time.
Attorneys love it. They're filing documents at any hour of the night. You can, from the comfort of your home, office, your car, file your documents. And they have embraced it like you would not believe.
With this system, as you're filing, you will be able to see availability in all the courts, who is where, which attorney, if you're an attorney, where you have other matters that have already been listed.
They can see schedules for judicial officers, and they can see whether there are scheduling conflicts, for example.
So that the court itself would not be able to double schedule an attorney for a matter, which would make life a lot easier.
You can actually get the system to auto-accept something, get your case number, and get your notification immediately.
As a matter of fact, because the rules that accompany this new process also make provision for service via this process, you've also accelerated the time within which you can serve the other side by this process.
We live in a sort of microwave age where clients are expecting that when they send you documents, they can get them back yesterday. And I think with this system, it will facilitate or being able to sort of please our clients a lot quicker.
Because in the absence of that, when you file a document manually, as we used to before this, you had to report back to the client, oh, we filed a document. Okay, can I get a copy? We don't have it back from the court yet.
A lot of times attorneys are able to blame the court because the clients don't know how to check on the file, or the clients are relying on the attorney to interface with the court office. So I think the e-litigation system, especially clients being aware of it and how they can contact the court office and interface with it, would help to eliminate some of that.
I'm gonna take one for the team and say, us poor attorneys, we get so much flack for these things happening, but a lot of times it's not in our control. I think this system is going to assist with that.
The public expects, and any litigant ought to expect, that my matter is dealt with and that it is dealt with fairly and timely.
Right now you file, it's on the system, it's uploaded with a notification, you know where you have to do. It cuts off the time which it takes to do any task by possibly about 80%. Our judges would now have everything at their fingertips.
A judge can walk with his tablet, access the portal, all the documents filed by the lawyers right there. They can create bundles.
There's the pack and go feature in that the materials that they want to read, they can download it onto their computers, save it into a folder, and read it at any time, whether you have Wi-Fi or internet or not.
The Court of Appeal is an itinerant court and it moves from country to country. And I'm sure the Chief Justice would have mentioned how burdensome it has been to move big boxes of documents from one jurisdiction to the next when they fly out to have hearings.
Currently, what we do at headquarters, as soon as one sitting is over, we are back to preparing for the next without a break. And we have to have our clerks basically collate all of that material, pack them into boxes, and we have to travel out with those boxes, invariably on LIAT. If the boxes are too many, there have been times when the court would have to charter a private plane. Now, how does that material get there? That material comes in, and invariably comes in by whether it's FedEx, courier packages, and then it has to be taken back out.
The airline, the costs involved of overweight and many boxes having to be calculated in terms of how much it's going to cost to put those boxes on the airlines, how much it's going to cost the Court of Appeal headquarters to pay for those overweights.
So can you imagine walking with a thumb drive in your pocket, which contains all of those bankers' boxes of material, as against paying the cost of all of those boxes to be taken from one state back to St. Lucia and back again. What a difference it makes in terms of costs and time and labor.
Operational efficiency, you could see being increased throughout.
So you move from that type of scenario, the lawyer cost and the material cost of producing that huge amount of documentation, to a much more streamlined and efficient system where everything is accessible electronically to the users in the court. That can translate into huge cost savings.
It's all uploaded, it's all online. Everybody can just get it right there. You don't need to get a process server to go to serve your documents.
So the idea is to make it transparent so everybody knows where the cases are stuck in.
The transparency is going to be heightened and significantly increased in that you can log onto the portal, log into your matter, and you could see every single thing that has happened in the matter.
If one is represented, then the expectation is that they would have to continue with their lawyer to get information pertaining to the matter. But if that person is unrepresented, then it's a responsibility of the court staff when that unrepresented litigant walks into the court to provide that litigant with every information pertaining to his or her case.
That's going to be important. At the moment, there is a perception that once it goes into the registry doors, it goes into some kind of black hole, something is done to the papers, and then eventually it comes out again.
Persons can go and see, well, this is how it happens electronically. You know, it'll take away some of the mystery of the legal system and the operations of the legal system.
It also takes out, I think, the factor of where a person may forget to really place on there a proper filing date and time, which may impact how a matter is to be dealt with. So that also, I think, is a plus in terms of taking out some of the vagaries of human behavior, in a way, out of the equation in terms of filings, processing, and that information getting to the attention of the proper officer in a timely manner.
The Eastern Caribbean Supreme Court's e-litigation portal vows to re-engineer the justice system with transparent access to the administration of justice from the time a case is filed to the moment a decision is rendered. The courts in each member state and territory have adopted a posture of change and was aptly prepared to keep the wheels of justice turning when the worst health crisis the world has seen in 100 years, the COVID-19 pandemic, hit the jurisdiction.
One may ask, was it fortuitous that we embarked on a project of taking the court fully online, from GEMS to the e-litigation portal? I say no. It was vision and the acceptability of the available technology to solve some of the problems that the court would have experienced with the inconvenience of storms and hurricanes.
I think if we're talking from a Caribbean perspective about the need for resilience, a number of us, of our countries, have experienced some devastating hurricanes.
And public e-litigation is something that we need because of what we saw has happened during and after the passage of Hurricane Maria.
Well, when Hurricane Irma came, we obviously had a problem. In the territory of the Virgin Islands, there was no power, communications were down, office buildings were destroyed, people's homes were destroyed, people's families were dispersed, and physical records were also destroyed.
Essentially, we lost a number of our buildings territory-wide, and the court was no less involved. It required the court, the commercial court in particular, to relocate to St. Lucia from where matters were heard.
We were able to do so mainly because at that time we had a rudimentary system of email filing of documents, and that coupled with our GEMS software, electronic software, which was then in use, enabled us to get the commercial court up and running without missing one scheduled hearing.
Irma was an unprecedented event in the Caribbean, and Anguilla was severely affected.
Hurricane Irma, it hit Anguilla about the 6th of September 2017. A portion of our building was just damaged. Of course, we got water damage. Also the court registry, they received some water damage.
Hurricane Maria's impact on Dominica was absolutely devastating, tremendous. The criminal court where we are functioning now was almost decimated. Every chair, the courts, the judges' bench, the bar tables, all those things were destroyed by the hurricane.
Our civil court suffered major damage. We lost files, we lost most of our equipment, because only the river came in, the sea came in, and then the roof of the building, also that was lost.
The registry was destroyed. It was severely compromised, and a lot of the files, the physical files, suffered damage and mold infestation and had to be dumped.
It impacted on the judges themselves, the court, the physical structure, the administrative aspects of the court were affected, and so the court wasn't able to sit.
There was an absolute halt to justice in Dominica for about 4 weeks. For me as a judge, I lost a lot of matters that were ripe for judgments, because once a matter was completed and we were awaiting closing submissions, those files were with me at Barracoon Building.
Where we had a tremendous challenge was at the DPP's office. Bear in mind that the building was totally de-roofed and the windows were actually removed.
It took a long time, well, quite some time, for us to match files with lawyers with respect to civil matters, with respect to criminal matters, and the DPP, which also was affected, the DPP's chambers. The roof had gone there, so the DPP had to reconstruct files, check our files there, make comparison, which documents are missing, which file is completely gone, which lawyer on the other side is involved, can we get the lawyer's file, can we reconstruct that file? A host of issues to be dealt with.
So we have gone through reconstructing files, providing them to the registry, which involves expense, which you have to pass on to someone, photocopying documents, making the files available to the court so that they can reconstruct them.
And I think this in itself has served to highlight the desirability of a more robust system that doesn't depend on physical storage of files and physical access to files.
So the court in itself, to be independent, must have a system that is robust enough to withstand any disaster. So it means therefore 1 week or 2 weeks after a major hurricane, that you can be certain that your files, the integrity of the files, are protected.
And we are now moving to scan everything into an electronic format, digitizing everything. And we welcome so very much the e-litigation portal, which will require from beginning to end all matters to be put in electronic format.
With the portal in the cloud, one would expect that a storm or hurricane would not impact the operation of your office, because your office really will be virtual where the court is concerned.
But even for the lawyers themselves, you can hook up. Just simply just, on the phone and your laptops, etc., and have access to information. And I think that in itself is a resilience to the core.
So I believe that the e-litigation system can only serve to enhance and improve the image of the court. And of course, in a practical sense, it does, of course, improve its functionality.
Our portal is hosted by one of the prominent industry standard cloud service, Amazon Web Services. With that service comes an extremely high level of security. And of course, as it is now, those servers are monitored 24/7 for any threat by hackers. That's one.
I can tell you that AWS, the cloud, it's a lot more secure than you can say in a normal data center. Okay, here in the data center, just imagine if system does go wrong, hardware breaks, whatever. Now, Amazon Web Services, it promises us a 99.95 availability, which means you can access the system almost like 24/7, anytime of the day, right?
And synchronized to multiple sites as well, because Amazon Web Services would not keep one backup. They would have several backups in multiple sites.
And I think fundamental to any court system, be it at the low court or the high court level, is the safeguarding and protecting of court documents. Okay? And there has to be a certain level of redundancy in that protection.
Apart from the server, the password that we provide, that we ensure users have in order to log in, we ensure that there's a high level of complexity.
Your user IDs and your passwords, everything is encrypted. And whenever you file or send data across, it is through a secure channel using SSL cert.
Now, most importantly, when legal practitioners come onto the system, there are two levels of validation. One, the registrar has to approve your registration. Secondly, you will be associated with a law firm. An administrator of that law firm must admit you into the system.
One of the things that we've had to really fine-tune and emphasize is that we need case managers at the court, because those are the persons who are going to be doing the first level of verification to let the registrar know that these documents have been filed.
You cannot do litigation without human beings looking at papers and making sure that they have been correctly filed. So court staff do not have to be afraid that their jobs will be written out. So we need this tool to help close that gap between filings and disposals.
But what has to happen, it has to be made easy, especially for the older practitioners. You have to do a lot of education. It is necessary. The court staff and the facilities have to be put in place and updated.
We've undertaken training with the various stakeholders. The actual process started with what we call user acceptance testing, where we invited different groups of stakeholders, lawyers, court staff, to sit with us.
We started with legal practitioners, then we went to the case managers, the judicial officers.
With the expectations of our clients that they must get more for less, there's no question that in order for us to be relevant and to even survive, that the technology is not an enemy. I think that it should be seen as a tool for us to more efficiently or better serve our clients. So I see it as a win-win situation, actually. We are grateful to the court for taking the initiative and showing the leadership that it has shown to take it on and to move this forward.
I am very much sold on the new system. I embraced and welcomed the new way of doing things. And I would once again like to commend the court, the Chief Justice, and those that went before her for the vision in implementing this new system.
I believe in the power of technology. I am simply committed to ICT. And I'm committed to it because I think that it holds the key to so many things that you can achieve.
I'm 100% in support. And I'm certain that the government has always provided the policy direction and support for the court. The court is an independent institution, and at all costs we have to ensure that we provide the tools of trade, be it by way of finance, by way of training, and whatever requisite support that the court needs.
We have seen the improvements in our courts. And e-litigation will be one step further in the whole question of the revolutionization of the court's operation.
It is going to be beneficial, and we have to give it a chance. And that's all I can say.
I do anticipate that there might be one or two kinks in the implementation process, but I think that we ought to be patient and give it a try.
More training obviously would be required down the road, but I think it's a good start.
I want to encourage my colleagues particularly to explore using electronic documents. It will help in the whole e-litigation because we have a role to play in making it work.
There will be wrinkles, of course there are, but you can't iron them out unless you actually use the product. And in using the product, then we will test it with fire.
You're really not living and doing and improving unless you embrace change. So that is the way that we have to go. That is the way of the world.
This change is good because the change is not motivated by one individual. It's motivated based on justice and persons wanting to ensure that our constitutional rights are well looked after. And this represents hope for the future. It represents a platform and a foundation by which we can do business in a way which serves our clients well.
What I would like, I think in the end, is to feel that I have done the best that I can in terms of moving the court in a direction of sustainability, efficiency, and really delivering, top-notch service to the people of this region.
The ECSC E-Litigation Portal, serving you on time and online.